Are we ready?
We're ready.
Thank you.
You're welcome.
All rise.
Good afternoon, folks. You may be seated. So good afternoon, folks. I'm Judge Brian White. We're on the record in Ocean County Superior Court. It's 1:48 p.m. on May 28, 2024. The matter of J. Lee Brantley versus Anthony Dixon under docket number FD 15465-14. Present in person in the courtroom here to be both the plaintiff and the defendant. Are both parties self-represented in this case?
Yes.
Mr. Dixon?
I'm here by special appearance. I'm not self-representing. I'm not here representing anything. I'm here as a man.
But you don't have an attorney?
Appreciate the question, but I'm not interested.
All right. Before I hear directly from my other party, I need to swear both of you in. Can you please both raise your right hand and be sworn? Will you swear or affirm, Mr. Dixon?
I appreciate the offer, but I'm not interested.
Do you swear or affirm that the testimony you're about to give will be the truth before this court?
Yes, Your Honor.
And your full name for the record?
Jennifer Grant.
Thank you. Mr. Dixon is inclined to swear or affirm to tell the truth. I'll simply advise him if he gives any testimony today that he's required to tell the truth. Mr. Dixon, can you place your name on the record, please?
I'm here by special appearance challenging the original support order from September 30th, 2016. Here by special appearance challenging the controversy. There's a lack of controversy. I want to go on the record, say that I've asked
Well,
the
if you're
mayor
going
for
on the
evidence.
record, can you just put your name on the record?
I appreciate your offer, but I'm not interested.
All right. This matter comes before the court by way of, well, there was a, last before the court, and a hearing took place on March 14, 2024. At that time, the court entered an order that provided the defendant father's application to address and modify parenting time was denied without prejudice. Defendant father's application for termination of child support based upon fraud, duress, and lack of jurisdiction was denied. Defendant father's objections were noted on the record, and the matter was closed. That was the last court event in the matter. Thereafter, a series of filings were made by Mr. Dixon. On March 22nd, 2024, at least on our electronic system, there were 3 separate filings challenging, it appears, child support, whether there was jurisdiction for the court to even impose child support, and similar objections to jurisdiction, etc. 3 separate filings, although I would note there was no formal application made. Although those were in some of the forms did contain certifications and notices, so they were, we say, partly compliant. And then on April 8th, 2024, utilizing the court required form, Mr. Dixon filed an application and seeking relief from child support, and also filed on that date was a more extensive certification, again outlining his objections to jurisdiction and fraud and assortment of other claims in that certification, and that had provisions that I think were the same that were filed in the previous filings on March 22nd and some of those prior there too. The defendant filed a submission on April 23rd, 2024, which appeared to refuse or contest paternity in the matter. Again, the child in the case is Kenzie Dixon, date of birth October 1, 2012. On April 25th, 2024, more filings from the defendant, notice of objections, and again, these were somewhat duplicative issues with the process and otherwise, seeking to disqualify the court, this judge, from handling the case. On April 29th, another form of notice motion was filed by Mr. Dixon. That requested relief relative to custody and or parenting time, to change venue to any other county, and to disqualify the judge. And on April 24, or also on April 29, 2024, assorted filings including seeking 50-50 custody and a psychological evaluation for the plaintiff, among other things. On April 30th, the defendant filed an emergent application that was denied, and noted that there was already a pending court date for today. On May 3rd, 2024, the plaintiff filed a cross-application seeking relief relative to child support, maybe a request for an increase, I'm not sure. I'll have to ask the plaintiff what she's seeking, as well as sole custody of the minor child and for a restraining order against Mr. Dixon. And then finally, last noted in our electronic system was a submission by Mr. Dixon on May 14th. And this appears to be a copy of some of the filings, but also a letter from the Attorney General's office. It appears these documents may be filed or sent to the Attorney General's office, and they were forwarding those along to Ocean County Superior Court as they felt they were appropriate here, it appears. And again, the copies, mostly I would say duplicative of the other filings Mr. Dixon made raising the assorted objections to the process, etc. So that is the procedural history that brings us to this point today. The matter was scheduled in person. Obviously, both parties are here. Mr. Dixon, this is your application. So this is your opportunity to explain to the court what you were seeking and why. And then, Ms. Brantley, I'll give you a chance to respond.
Appreciate it, Mr. White. I'm here by special appearance, challenging jurisdiction, but before even jurisdiction, I'm challenging the standing and the controversy. I've supplied paperwork demanding for evidence that there was a controversy. There hasn't been any rebuttal yet from the plaintiff or the agency or the court.
When you say agency, what agency are you referring to?
The agency at 213 Washington Street that's been sending out all the correspondence, sending out all the correspondence that's been coercing people to come to court, the same place, 213 Washington Street.
Is that child support, or probation, or the court itself you're referring to?
It's not child support. It's Title 4D agency. Blessing versus Freestone, it shouldn't be called child support. It's not in the benefit of the child or the mother. It's Title 4D agency at 213 Washington Street, sir.
And what are you seeking that the court do today?
As a man, I'm seeking the court. I'm demanding the court to throw this case out, dismiss this case, or write your order so I can file my appeal and file my lawsuits.
These disputes with jurisdiction.
I'd like to go on record that the court is, and the agency of plaintiff is in tacit acquiesce. It's non-rebuttal. There isn't any counterclaim, counter evidence to show that there is any controversy before the court. Controversy can't be for a mother just to show up to, a building and pay $35 to request services. I've not signed any contract, knowingly or willingly.
Are you
And
referring to the financial obligation that the probation is?
I appreciate your question, but I'm not interested. I'm here by special appearance challenging the original order from September 30th, 2016 for the original support order.
Mr. Dixon, I'm looking at the old file. I have an order. You said September, what date? I'm sorry.
The very first support order was heard by by Mr. Michael Collins, quasi-judge.
All right, and I have it says September 29th. I think it's the
Was it?
same order.
30? I don't know why it says 31.
September 29, 2016. It's actually that, on the hearing date of September 29th, it looks like the order was signed on October 3rd, 2016. So
Okay.
it probably took a couple days to get it finalized. But I believe that's the order you're referring to, and that appears from my review of the file, the first order that establishes the child support obligation, it indicates at the time $104 per week, $16 for arrears payment. So it was $120 weekly. So
Yeah.
that's the order,
I object. That's a void order. There's no
I'm sorry, I
state.
couldn't hear you, sir.
I said I object. That's a void order that you're referring to. It's a void order.
Well, I thought you just said you wanted the court to vacate the order. Is that the order you're referring to?
It's a void order.
I don't understand what you mean. Are you seeking to be voided, or has it been voided since?
It's a void order.
All right, I'm gonna hear from Ms. Brantley. I'll come back to you, Mr. Dixon, if you have anything to add. Ms. Brantley, what would you like to tell us?
I would just like me and my daughter to be safe and left alone. I have been raising her by myself her entire life. Mr. Dixon has caused nothing but severe threats, harm, and just financial burden in any which way he possibly can.
Objection. Can I really?
Hold on.
He makes
Is
it-
there an objection? What's your objection?
I would like to know what the harm is. Where is the harm? Where is the actual injury? In fact, you can't keep saying that
All
stuff.
right,
in
I'm gonna ask that question and to give the plaintiff a chance to explain.
My fault, Mr. Wright.
There has been multiple cases of him threatening us verbally to kill me, coming into our house and causing harm, physically trying to throw things at her from when she was a little girl.
When are these incidents?
They are all recorded in the long history before the courts, and there's been criminal charges pressed against him. Mr. Dixon makes it very clear he wants no responsibility whatsoever for Kenzie. It's very clear. So I'm a little confused at this point, where this is now my second time I'm going for full custody. Judge Russo felt compelled that I had all of the statutes to have full custody of her, but gave him one more chance. That led to years of just harassment, nonstop threatening my job, which is in the court, there's a letter, everything, trying to do everything that is not in the benefit of Kenzie. I literally cannot name one thing that Mr. Dixon has done that is in the benefit or best interest of Kenzie.
Well, does he, for the most part, pay his child support?
He has not for months, no.
But prior to the last few months, it had been relatively consistent?
In the beginning it wasn't, and then there was probably maybe a year and a half, 2 years of that, and then that was it. And now his whole thing is that he is a sovereign person and he wants nothing to do with her. And then the other sentence is, oh, I want to see her. Well, then do what you were supposed to do, because you agreed to have a psychological evaluation with a thorough person to pay. I paid, even though I take care of her, I paid my portion. He refused to do it because he has been over and over multiple times unsafe. Every time he encounters her, it's anxiety. I had to put her in therapy. I had to work with her. She was terrified. And now she wants nothing to do with him, because every time he has ever tried to do something over the years, and now it's been probably 6 years that she's even talked to him or seen him, and she wants nothing to do with him, because anytime the court had tried to put something in place, which Judge Duran tried super hard to get Mr. Dixon to actually be a safe, suitable human being just to be able to be present around the child, and he failed to do it. He can't control himself. It's very obvious that with all this facade that he's putting on right now, he's not stable. He can't even function as a human being. So the reality is the court has made it very clear that there's nothing that's going to happen unless he takes the thorough evaluation with Karen Donahue. He needs to know that he's even safe to be around
Was
her.
that, if I recall, was that when there was an order for reunification therapy?
Yeah, that needed to happen. We've never lived together in the same house. I've always raised her. There was
Objection.
always supervised
I'll hear
visitation
you, what you said.
when she was little, and then we got to years where there hasn't been anything because it was so traumatizing to her, and it continues over and over again. So not recently, after that last court hearing that we just had with you, sir, we literally we're at church and we're getting a phone call because he's demanding the Jackson police to talk to her, and she's like, Mom, why do I have to talk to the police? And I'm like, baby, they just need to know that you're safe and you're okay. And the police were like, listen, I don't know why he's coming here. He lives in Manchester apparently. They're like, but he's coming here and he's demanding things from us. Got her all upset that night. How to work through that with her, because nothing that Mr. Dixon has ever done is in the best interest of Kenzie. Never. I literally cannot think of one thing that has been good in the best interest of her. So this Mr., I don't know if she's my child, and then she is my child, and then I want this and I don't want that, like, I don't know when you guys as a court system, like, are gonna be done. I'm tired of being threatened. I'm tired of being harassed. It's not healthy in any shape or form for me and my daughter.
And there's no active restraining orders between the
We
parties?
have tried multiple times, but because we do not live together and I don't respond to anything that he sends me, harassing emails and all of these threats with his little fine words of trying to like, oh, I have the upper hand. Like he's very threatening, but tries to get around it, and then he thinks he's slick, quite frankly. And it's like, I'm not responding to you because you don't do anything that is going to be safe or productive for her life.
All right, thank you, Ms. Franklin.
Is that all that is on the record, please?
Everything's
on
on
record?
here is on the record.
It's court of
So,
record? Appreciate you. Thank
Mr.
you.
Dixon, as I indicated, I give you a chance to respond, so what would you like to tell me?
I'm here by special appearance challenging the original order from September 29th, 2016, the original support order, demanding for a contract with my wedding signature on it. I have not received, there's no evidence to the contrary from the plaintiff or the agency.
All right. I think I know your position with regard to the child support order that you object to. Do you have a position as to the cross application by the plaintiff whereby she's seeking sole legal custody?
I appreciate the question, but I'm not interested.
And it's mentioned in different points in your paperwork that you're seeking parenting time or access to Kenzie. Is that accurate or not?
I appreciate the question, I'm not interested. Just here to challenge the original support order.
Is there anything else that you want to tell me, Mr. Dixon?
No, sir.
Is there anything else you want to tell me, Ms. Franklin?
I want sole legal custody, and I will drop the child support because I'm not going to be harassed for the rest of my life, and my daughter is not going to be threatened by his behavior.
Objection.
Your objection?
Just, it's evident that the mother, who is a social worker, isn't going by her own child handbook with, after air and food, the next best thing for a child is the father and the mother. But like I said earlier, I'm here by special appearance, challenging the original support order. Just want to get that on the record.
All right, thank you. So this is an application filed by the defendant's father. It's largely seeking to terminate or vacate the child support obligation as the defendant's father has submitted paperwork largely incoherent, if I'm being honest, citing confusing
Objection. There's nothing confusing about it. It's all federal Supreme Court law and state Supreme Court law.
And your objections are noted.
Appreciate it.
Seeking to void the order for lack of jurisdiction over him or the controversy. And the court finds that those assertions are not legally sound. In addition, I would note that the court ruled on this matter on March 14, 2024, and these actions, a series of filings were made by the defendant father, but they began March 22nd, virtually a week later, and have continued in the same vein, but don't cite any change of circumstances or anything different from when the court ruled on this. This was not a motion for reconsideration, although in some respects it seems to be. He's asking the court to once again consider his arguments, and to that extent it would constitute an attempt for a second bite at the apple, so to speak, on the issues that have already been raised. I'm not aware of as to whether an appeal of the court's decision on March 14th was made. That's Mr. Dixon's prerogative to file such an application. I'm not aware whether or not it's been made. And in attempting to engage Mr. Dixon to further explain his positions, he is were reluctant to say more than his generalized disputes with jurisdiction in the process, etc. He's done it all respectfully, certainly, but has not really provided any substance to his filings.
Objection. I've been demanding the undertaking in the contract for months since January. Have not received any evidence yet.
Your objections are noted.
Appreciate you.
This case has a very long history. The court did last time and this time review the file. Not page for page, that would be a serious undertaking, but had refamiliarized itself with the complicated history. And there's orders over the years that largely have to do with mostly with parenting time for Mr. Dixon. And it was cited, I think, in one portion of his filings, and noted that there was a time when Kenzie was supposed to be brought to basketball practices, and the plaintiff, according to the order, did not comply with that, and there were some sanctions imposed, suspended, but it's noted that there was at least a point in time where there was, Ms. Brantley was found to not be in full compliance. But there had been multiple orders thereafter trying to ascertain a process to provide the opportunity for some parenting time, which had historically been Mr. Dixon's main request. And this case has been through several judges, but when it came more recently to this court, an order was entered designating Dr. Donahue as a reunification therapist, because the plaintiff testifies today it's been about 6 years since Kenzie and Mr. Dixon had any real contact, and even a couple years ago, it was 4 years ago, or give or take, and due to that length of time, the court had found that some professionals should be engaged to help that reconnect happen, if it were to happen.
Objection, please.
Your objections are noted. For the benefit of Kenzie, to make sure the experience would not be too traumatic or too disruptive.
Objection,
Probably
bias.
It would have to be somewhat disruptive by nature of it, but a process was put in place, and I'm referring to an order back in May of 2022, and the court determined that the cost of that would be split 75% for the defendant, 25% for the plaintiff.
Objection. That was a bias order.
Your objections are noted.
Incentivized by the Title 4D
And on
agency to rule in that type
Mr.
of
Dixon,
order.
with a standing notation that your objections are noted. And then months later, November 16, 2022, the court entered another order vacating that the prior order with regard to reunification therapy without prejudice. And I would note the plaintiff mother had already paid her portion. But the defendant had indicated he could not afford it. And the court provided any subsequent application by the defendant filing regarding parenting time should include an achievable plan for reunification and/or supervised parenting time that is monitored and managed by a qualified provider. Mindful of the financial strain that was claimed by Mr. Dixon, he was given the opportunity to come up with something in the alternative. If the cost of reunification.
Objection, bias order. Been challenging jurisdiction and standing in controversy from the beginning. You're mentioning a void order over and over and over
Those
again.
objections are noted.
Those void orders are
And
not in the.
denied, incidentally. But this new series of applications that resulted in the March 14, 2024 order and this hearing date really largely raised the objection issues that Mr. Dixon notes frequently on the record, and never provided any meaningful plan or realistic attempt to in a any healthy way, try to, in a realistic way, try to seek parenting time with Kenzie. His objection or concern largely is his objection to the original order back in 2016, establishing the child support. I don't find his arguments persuasive. I think they're legally false, and his application to modify or terminate child support or vacate the prior order is denied, as is the balance of his requests, which are hard to follow, but there's some minimal requests for parenting time, but they didn't express today any real request in that regard. So that is denied.
Objection, can I get an explanation and clarification for each denial that you're, I don't know, I'd like to get
the
one.
explanation, and you
Please.
can get a copy of this record.
Yeah, just need clarification, thank you.
So next is really dealing, so the defendant's applications are denied in their entirety. And I would note, there's been no change in circumstances, these were all really addressed weeks before these new filings commenced. Moving to the plaintiff's application, and today she really cited her, in her application, she cited a request for a restraining order, noted that there had been prior applications that had been unsuccessful. This is not the venue where the court can grant a restraining order, so, and the plaintiff seems to acknowledge that, so I'll deny that without prejudice insofar this is not the forum for that type of application. Really, with regard to sole custody, the court considers that application, and that was also it wasn't addressed directly in the prior order in March 14 that really denied the prior all of the pending requests of the defendant's father. And Ms. Brantley acknowledges she's made this application in the past, and it's been denied without prejudice several times. But the court heard her testimony, and in considering that has to review the factors under NJSA 9.2-4. And I believe at this juncture, based upon the passage of time, it's been now over 2 years since the last application resulted in an order that provided a pathway for parenting time and resumption of a relationship between Kenzie and Mr. Dixon. And if that was a reasonable possibility, the court would not likely consider modifying the custody arrangement, because if dad is in the picture and is involved, then his voice is entitled to be heard and considered. But we're 2 years down the road from that being a possibility, and nothing has happened in that respect, and in fact it looks even more remote than it ever will. And the concern is that the continuation of the joint legal custody status, which is not reflective of the status quo in any way, shape, or form, that's been in place for multiple years, is not a device that may enhance or assist in reunification between dad and daughter. It's more able to be weaponized and used as a basis to disrupt Kenzie's existence.
Objection. Just the same way she hired her first lawyer for the support order, Stacey Kerr Tomlinson to perform vexatious duty. Stacey Kerr and her conspiring to perform vexatious acts for the court to be an annoyance upon me to violate all of my federal and state rights.
Objections noted.
Appreciate it.
So in deciding the request for sole legal custody, the court has to consider the factors under NJSA 9.2-4. First is the parties, the parents' ability to agree, communicate, and cooperate in matters relating to the child. That is non-existent here. And to the extent either party.
Objection because of this is bias. Order.
Mr. Dixon, I note your ongoing objection. So I find that slight weight in favor of the plaintiff insofar as when reunification therapy was ordered, she cooperated and did her part, and that demonstrates at least some willingness, even though she clearly has issues with Mr. Dixon. That's not in doubt.
Objection. It was a vexatious order for me to pay 75% of $5,000 per month.
Mr. Dixon, please
It was vexatious.
refrain from interrupting the court. The next is the parent's willingness to accept custody and any history of unwillingness to allow parenting time not based on substantiated abuse. I'm going to call this a neutral factor simply for the fact there was a time when an order found that mom had not followed the order with regard to parenting time, so there is some history of that. But I'm going to make that a neutral factor because Mr. Dixon has not accepted custody or anything whatsoever with regard to these prior determinations. But on balance, I'll call that one even or neutral. Next is the interaction or relationship of the child with his parents and siblings. Again, the only information I have at this juncture, at least, is that the minor child has been residing with the plaintiff's mother virtually her entire life. And
Objection. You're speaking as a first-hand witness. Demand for recusal.
for that.
Speaking as a first-hand
that
witness.
request is denied. So that factor weighs heavily in favor of the plaintiff's mother because there's less several years in.
May I ask you a question, Mr. White?
Relationship between the defendant and the minor child. Number 4 is the history of domestic violence, if any. There's been some minimal testimony about the past in that regard. At this juncture, I don't have any direct evidence of that. There's apparently been some restraining orders that were never finalized, so I'm going to determine that as a neutral fact. Next is the safety of the child and the safety of either parent from physical abuse by the other parent. Well, as far as between the parents, the parties have not been in a relationship for many, many years, so that it appears to be remote risk. And the safety of the child, I have very little information as to any safety risks. Ms. Brantley testifies that Mr. Dixon is unstable, but the last time he's had any meaningful parenting time was many years ago. So I'm not gonna find for either party on that. That's a neutral factor. 6 is the preference of the child with a sufficient age and capacity to reason so as to form as an intelligent decision. I'm aware that Kenzie had been interviewed in this case several years ago, I believe by the court. No?
She was too little.
Maybe then, all right, so,
Which we did for her behavioral health.
that's, I read a report. All right, insofar as that was not a court interview, and she's probably old enough now to be interviewed, but I haven't conducted an interview, so that will be a neutral fact. Next is 7, the needs of the child. 8, the stability of the home environment offered. 9, the quality and continuity of the child's education. Those 3 factors clearly weigh heavily in favor of the plaintiff. The status quo has been, mom has been the one providing for Kenzie's needs. She's been living with her.
Objection. Mom has been parental alienating. That's all mom's been doing. Parental
Objections
alienating.
noted.
Thank you.
And education has been through mom and mom alone, at least for the past several years. So those weigh heavily in favor of the plaintiff. 10, the fitness of the parents. I don't have any information. There's been assertions of concern primarily with Mr. Dixon, and he's had some concern for us about Ms. Brantley, but I don't have any information that would make me determine at this juncture that either parent is legally unfit to parent. That's a neutral factor. The geographical proximity of the parents' homes. I'm not sure where Mr. Dixon lives. I have Manchester and Jackson. All right, so the parties are close enough where a co-parenting relationship would be possible. That's a neutral factor. The extent and quality of the time spent with the child prior to, subsequent to the separation. There's minimal information on that other than really that weighs in favor of mom, because Kenzie had lived with her mother virtually her entire life. And although there was times some years ago now where she did have a relationship and contact with dad, it was never, from my review of the filing to the file, never a 50-50 type of balance.
Objection, because she found a lawyer that could be vexatious and use layers to create a wedge between the relationship of the offspring and the father.
Your objections noted.
Appreciate it.
13 is the parent's employment responsibilities. I don't really have any information on that, the age and number of children. Kenzie, she's 13, I think it'll be 14 in October.
No, it should be 12.
Oh, pardon me. So, weighing those factors, many are neutral insofar as what is limited information of those factors, but all of the ones that have any real applicability weigh heavily in favor of the plaintiff's position. It's not really contested that for the last 5-6 years, Ms. Brantley has been acting as the sole custodial parent.
Objection, time to speak.
And the path
No.
to rectifying that really has not been taken by Mr. Dixon in any meaningful way.
Objection, time to speak.
Do you want to speak? Did you say?
Objection, time to speak. Time to speak for me.
You
Time to
want to
speak.
speak is what I'm asking. Do
Time to speak.
Would you like to speak, Mr. Dixon? Please do so.
I just want to ask you a question. Are you a judge right now? Is your status a judge right now, or are you a Title 4D contractor?
All right. The court's not answering questions. The court will give you an opportunity to speak.
I just want to know. Advice. Toomey versus Ohio. Quasi-judges being incentivized to rule in favor of the mother. Appreciate it. Thank you.
So balancing all those factors, in recognizing the status quo that's been in place for many years, the court is going to grant the application for the plaintiff's mother to have sole legal custody of the minor child and sole residential custody of the minor child. That does not mean a new application cannot be filed, and Mr. Dixon can set forth a reasonable plan to have a relationship with Kenzie again. Based upon my prior orders, I think would necessitate the involvement of a professional to make sure it's done in a way that is least disruptive to Kenzie. The court would be open to that. It agreed to that in the past. But absent that, I think it's clearly in Kenzie's best interest that the status quo be now formally recognized in the court order. So the court will grant that application. I'm taking no position with regard to child support. I've denied the application to terminate it, and I know Ms. Brantley had raised it, but I didn't have enough information whether to recalculate it. I'm going to leave it in place, and I know she, whatever position she takes, she can file a new application, but I'm going to leave that status quo as well at this time, and that would conclude the order of the court. So if everybody just sits tight for a minute, I'm going to dictate the order so everybody can have it before you leave, so stand by. This is FD 15-465-14, considering yourself a person. Plaintiff mother appeared in person, defendant father appeared in person for the reasons set forth on the record. The court orders this follows. One,
Objection. I didn't appear in person. I appeared as a man.
Okay, I'm gonna use the phraseology in person, I think it's the same.
It's
Defendant's
not the
father
same.
application to modify / terminate child support and vacate prior to orders was denied. Not done number 2. Defendant's father's other requests for relief are denied in their entirety. EIR. There, yeah. Three, defendant's mother application for sole legal custody. For sole legal and residential custody of minors on the screen. Any future application by defendant father regarding parenting time should include an achievable plan for reunification and/or supervised parenting time that is monitored by a qualified provider. This matter is closed. All right, that will conclude the hearing. I wish you both good luck. Thank you.
All right.